prosecutors with no evidence at all filed.
I
Zero.
recognize that. You have a lengthy criminal history, so I'm sure you've seen a lot.
Right. But
I'm explaining to you how it works in England County, okay?
Right.
All right.
I've been through England County.
Okay, I'm sure. You pay your fines within $500 within the next 7 days.
We could solve all this if they would stop.
I excuse me?
If she would have never.
Do you want a contempt while we're here? Because we can make it happen.
All right.
And that one won't be with the fine.
All right.
You understand?
Yes, sir.
Okay. Learn to control your mouth when you're in court. You have an attorney to speak for you. Let him do it. You paid him $7,000.
Well, I guess I want to start with why we are here today specifically, Your Honor. This court, I think, has had the opportunity to review the procedural history of this case. The underlying charges started out as a felony, a felony case. This court heard preliminary examination. It got bound over by a probable cause standard. My client and I were ready to try the case when it was a felony, and there were felony charges. It was remanded to district court as a misdemeanor case. We were ready to try the case when there were misdemeanor charges. And in the interim, my client violated bond, obviously, and he's admitted to that. But I give that history just to illustrate that I think the proper consideration for this court is not what the underlying charges were, but what the bond violation was. Bond violation, my client, he violated this court's orders. That needs to be taken seriously. We're not disputing them. That said, what he is found to have violated for is, and I'm not justifying it, but just to put it in context, it's a fairly run-of-the-mill disorderly conduct type case. It's the sort of thing under MCL 769.5. If this court were sentencing as a substantive separate crime, there would be a presumption against probation in jail. And the case is presently pending. The underlying charges, the charges relating to the bond violation are pending in 55th District Court. My client's currently on bond with Judge Allen. If there is a conviction in that case, whether by plea or jury verdict, I can pretty much guarantee this court that Judge Allen is going to put my client on probation for that. I'm asking, Your Honor, not to justify violating this court's orders, and not to say that that's okay, but I'm asking ultimately for a fines and costs sentence for the probation violation. I do know that it's a bond violation. I also want to address one other thing. I know probation has yet to receive my client's substance abuse assessment that he did at Cristo Rey. He has provided me proof that he paid at Cristo Rey. I can show the court if the court needs to see that. We just haven't, for whatever reason, haven't been able to get the assessment from them. So we will provide that to the court as soon as we can get it. But it's not because my client didn't do it. It's just we haven't gotten it from the agency. I'll leave it there. Thank you, Your Honor.
I know that there was the victim from the underlying matter here that she wished to make.
I don't know that she wants to make a statement, Your Honor. I think she just wanted to be present.
Okay.
Ms. Borman, is there anything that you'd like to add?
I suppose. I understand the bond violation wasn't specific to the situation that brought us here. I am concerned when it comes to the violation, the dismissal of court orders. The substance abuse piece doesn't pertain to me, more what brought us here to begin with, and the understanding that we may have the freedom of speech to say the things that we want to say, that there are consequences to some of our speech and our actions. And just having that addressed in conjunction with the legal side of like those consequences. And also I am working to get the PPO information and refiling and having him served, which I have not been able to do as of yet. So I just ask that the no contact order remain in place while I work with the court for the PPO.
Did your client want to make a statement at all?
I would like to make a rebuttal to it.
A
I
rebuttal?
would like to make a statement.
No, you're not gonna address her. You can address
I
me.
can
though.
address you.
You're not gonna address her or her request either.
I'm not gonna.
We're gonna address the bond violation, which is what you're here for. Because the underlying matter, you're not here for. That's been dismissed.
I do have one question. It's been dismissed. Why is she here?
I have no idea, but she
But
she appeared.
So I'm allowed to say something.
I agree. I'm
in
not
my
going to,
face.
but you ask your attorney while she's here, and your attorney can get that information from the prosecutor's office. I am not addressing that. I asked you, did you want to address while you're here to be sentenced before I impose a sentence?
Through the law.
Oh, okay. On the bond violation, I'm sorry I didn't follow your orders. And, definitely didn't realize it would get to be all this, I guess.
What did you think was gonna happen?
Yeah, I guess I didn't think, to be honest with you, especially when the charges got dismissed. I just find this whole situation has been just a roller coaster ride from the beginning. I don't know if you've read it all. This started by somebody not knowing the law that worked for the government came to my house. I regressed it online, and maybe it was lawful or not, but it must have been because it's been dismissed. So for over a year, I've been on bond with this court. A government official came to my house, knocked on my door, and didn't even know the law. The woman that, I'm not trying to address her, but she came from CPS to my house, said it was illegal for my son to have a marijuana card. I told her, ma'am, it is not illegal. You should probably leave my house and go look up the law. If there's still a problem, get back a hold of me. She never did. She kept going. I posted her picture online. That was my only recourse. I called CPS. They told me if I come on their property, send me a letter, a no trespassing, like I'm a friend. So from the beginning of this, she came to my house unlawful. She's made it on court record. She said she didn't know that was the law. My lawyer didn't know that was the law. I think even one of the judges in this didn't know that was the law. I knew that was the law. I was in the law, in following the law, minding my own business in my house. And since then, we've had this fallout. I've had 2 felonies, 2 misdemeanors. She's tried to file a restraining order on me. I've never even met the woman in person. She was on my camera at my house. I posted a picture of her online and said she was at my house unlawfully. She tried to file a restraining order, was denied. She went to Meridian Township Police, tried to get them to file charges on me, denied. She went to Lansing Police Department, had them call and threaten me over this post, denied, no charges. She then goes to her friend who she works with every day and files a charges on me. She works with this prosecutor, their CPS, and this woman, if you look this prosecutor up, she prosecutes cases against children. That's her specialty. But this is a friend thing. Everybody else has to press charges, normally calls the police. I've never seen anybody circumvent 2 police departments and a restraining order and get a prosecutor that can convict me. I'm dead wrong for drinking against your orders. I am dead wrong for that. But this whole fallout from someone that didn't know their job coming to my house has been a nightmare. I was charged with 2 felonies, 2 misdemeanors, and all I did is say she came to my house without knowing the law. She did. And then she.
Is that all you said?
Online, if you go look, that's what I said.
Okay.
And I asked for information on her, and I was hoping other people had the same problem, because that's the way of the world today. If you have a problem, you go to the internet and you air it there. When I called down to CPS to air there was a problem, instead of them doing something about it, they send me a threatening letter. So everywhere I turned, I've got a threatening letter or a charge out of this. I'm dead wrong for drinking on your bond. But Clearly, I wasn't dead wrong. The only person dead wrong was her coming to my house in the beginning and not knowing her job. If she had known her job, none of this would be here. I spent $7,000 on an attorney. I've taken countless days off work. I've been to jail, all for her not knowing her job and starting something. I posted online that I wasn't happy with what she did. She came to my house unlawfully and didn't know her job.
Okay, so my understanding is the underlying issue was that she came to your house as a CPS worker.
Unlawfully. She
Well,
didn't know her
look,
own
I'm not gonna
job.
I don't know the details, but this is part of her, she came in execution of her duties as a CPS worker.
She thought she was doing.
Well,
it.
I don't
She
want you
later
to,
admitted
I'm
she
not
was
asking
wrong.
you to opine, because this is not a matter that went to trial, correct?
Well, that's right, Your Honor, and I was trying to,
Yeah, it's not gone to trial.
It was dismissed. She admitted on your
So-
record she
so-
was wrong.
Your Honor,
It
we
was
were.
dismissed per plea agreement. Let's
No,
be
no, no.
clear.
Yep, sir, that my understanding is this was not litigated,
Okay.
correct, counsel?
That's right, Your Honor.
Thank
We
you.
had a preliminary
It was not
examination.
dismissed on any merits. You weren't given, exonerated in this matter. You just made a statement on the record that you just made a comment about one thing, but I have the screenshot of what you put on social
Right.
media. You were soliciting dirt on her,
Right.
correct?
Right.
Because you wanted to create a problem because you felt like she was creating a problem for you, correct?
Well, I figure. if
I could
there's
use
another-
that dirt.
Tomorrow, if someone posts the same thing and I.
I
see
know
that
someone
post,
knows her and has some dirt on her, I can use that dirt. That doesn't seem like, what you said is when there's a problem, the way of the world is we go to social media and air our grievances. This is not you airing grievance. This is you posting her picture so that you can, and asking people particularly, I know someone knows her and has some dirt on her,
Right.
so that you can get the dirt because you wanted to use it. That is not the same as you airing a grievance. That's not the same as you making a post saying I believe this person unlawfully came to my house. That's not the same thing. What you were doing in this looks like you were looking to create a problem. That's what it looks like. I don't know what your intent was. This again was not a matter that was litigated. I just know what the plain language of your text messages indicate, that you were looking to create a problem for her because you felt like she created a problem for you.
We were
The other-
looking to litigate.
The other concern, I didn't ask you, were you looking to litigate? I recognize that you hired an attorney, he made it clear on the record he was prepared to go to trial. It wasn't. At this point, it's been dismissed per plea agreement, and your attorney could advise you. Plea agreements happen for another number of reasons. Just because the prosecution took the position to dismiss this per plea agreement does not mean that they don't believe that the case has validity. It's not what that means. So you shouldn't assume that and then go proceed in the actions that you were proceeding on because of that. Because you could find yourself having another bad year if you do that. You
Right.
understand that?
Right.
And that's not what you want. You want to get this behind you, hopefully learn something. I don't know what you and Mr. Cruz talk about in private. It's none of my business, but hopefully there was some counsel in there that advised you that even though you came out on top when it comes to the plea agreement here, you don't want to engage in this kind of behavior. Even if you never get a conviction, look at the year that you had because of it.
You told,
Yeah, like,
definitely
you
told
don't
me, I'm
want
gonna
that.
hire
It's
a lawyer.
not meaningful for you. It's
Right.
not meaningful for your child. It's definitely not meaningful for your bank account.
It's not been meaningful in anything.
Yeah.
Nothing positive has come out. of it.
Absolutely. That's not the way of the world. We don't, as adults and professionals, address our grievances on social media. That's what kids do.
Right.
You're a grown man.
I feel like with that said, when I called down and told them that.
I'm not asking you all that.
Right.
I'm talking about you saying that the
Right.
way of the world is that's not the way of the world. It's not appropriate. Okay, and this again was not an issue where you were just addressing a grievance from what I'm reading. It was looking like a solicitation for some dirt. Nonetheless, I recognize you had a bad year, and I appreciate you taking responsibility for your actions in the regard of you violating the court's order. You were arraigned in this matter back on June 16th, 2023 by the magistrate Millmore, and you had certain conditions. And not only did you pick up a new charge, which was disorderly conduct or disturbing the peace, but you were impaired, visibly impaired is what the report says, which was in violation of your bond condition not to use, purchase, or possess alcohol or drugs without a valid prescription. And I don't care if your case is pending for 1 year or 3 years. I don't care if you believe there's evidence to sustain your guilt or there is evidence. If that's the conditions that you're met with, then you have to follow those conditions unless your attorney comes to the court and makes a motion, Your Honor, can we have these conditions removed for X, Y, and Z purpose? That didn't happen here. So what we have here is something that demonstrates a blatant disregard for what the law is telling you to do. That doesn't fare well for you. You understand that?
Oh, I understand.
You have a pending matter. I have no interest or intention to put this man on probation for a violation of this bond condition, which he has a pending matter on. I'm even surprised he took a plea to it when he has a pending matter on it, but that's a whole nother issue. You will be getting a fine though. Do you understand that? Good luck to you and whatever you got going on over at the 55th District Court. Your fine in this matter is $500. When will you be paying?
I can pay it by the next week if you don't mind. You want it today? How you want it?
When are you gonna pay?
I can pay by next week with it. You guys charge these a credit card, so I'm just.
So I'll notice you'll be paid within 7 days.
Yep.
Any additional matters for the record?
I just want to place on the record, Your Honor, that just for the record, this case, the underlying matters was found over, it survived a motion to quash. The dismissals were not on the merits. I chose not to try this case in circuit court on Judge Dragonchuk's docket. And when the case was remanded here, and there was a bond violation, I chose to negotiate a plea on what I knew that Mr. Barron would plead to. Rather than drag Ms. Borman through a jury trial in this courtroom. So the court was right when the court indicated that a plea bargain was negotiated, not as a result of any decision by the people on the merits. I would also indicate for the record that there was no denial of the Meridian Township Police report. Meridian Township investigated it, referred it to the Lansing Police Department because Lansing had jurisdiction. Lansing didn't deny it. They submitted it for charges. It was reviewed by me because it landed in my queue and I reviewed it.
Not because you're friends.
Not because I'm
Ms.
friends.
Borman, who probably just works for Ingham County as well.
I do know Ms. Borman and I do work with her professionally, but sometimes I do review cases that don't have to do with child sexual abuse or child physical abuse, because sometimes we're overwhelmed and my office assigns things to me that aren't related to that.
I recognize it, and I don't think it's fair for the defendant to make allegations that they're friends and that this was moved forward because of that. I don't even know where you got that information from, but the prosecutor works with, the prosecutor's office works with people who work in all of the departments of Ingham County, whether it's child protective services, whether it's the public defender's office. That doesn't mean that they're friends or that they're working in cahoots. That's something that your attorney should have dispelled. So that you would understand coming in here that just because they both work in Ingham County doesn't mean that they're friends. You understand that?
Yeah.
I don't know anything about their personal relationship, but I'm just saying that we can't assume that just because they work for Ingham County, that they're friends and that this was prosecuted because she picked up the case because she's friends with the alleged victim in the underlying matter. That's not how cases are issued.
Well, this whole thing of everybody.
And for the record, this prosecutor can't just decide I'm gonna go take a case. I don't know if you knew that.
Okay. I've seen prosecutors with no evidence at all
I
filed. Zero.
recognize that. You have a lengthy criminal history, so I'm sure you've seen a lot.
Right. But I've seen.
But I'm explaining to you how it works in Ingham County, okay?
Right.
All right.
I've been through Ingham County.
Okay, I'm sure. You pay your fines within within $500 within the next 7 days.
We could solve all this if they would stop.
No, excuse me?
If she would have never.
Do you want a contempt while we're here? Because we can make it happen.
All right. All right.
And that one won't be with the fine.
All right.
You understand?
Yes, sir.
Okay. Learn to control your mouth when you're in court. You have an attorney to speak for you. Let him do it. You paid him $7,000. Let him do it. Okay?
All right.
Have a good day.